So let me introduce you now to your presenters today. So we're joined by Jay Gandesha from Davis Grant, director here. I'm going to hand over to Jay shortly. And he's supported today by Alan Mills and Katie McLaughlin from Supportis, who are specialists in employment law. So this whole session today has a gear around people and tax, effectively. I hope that you find it enjoyable. And at this point, I'm going to hand over to Jay to take it from here.
Thank you, Jo. Good morning, everybody. I'm going to be talking about the upcoming changes to pay and your payroll. So April marks the start of one tax year, the end of one tax year and the start of the second one. And this year, as is common with every tax year, we see some changes in statutory pay and payroll procedures. We're going to be seeing changes in a week's time. Can you imagine it's 5th of April next Tuesday, in changes in national minimum wage and living wages, national insurance contributions, statutory sick pay, statutory maternity, paternity, adoption, parental pay, and shared parental pay. If we can have the next slide, please, Jo. So as listed on there, those are the changes we have. And we're looking at the minimum wage that's going to increase from this Friday. Jo, could I have the next slide, please? The national minimum wage and living wages will change from this Friday, the 1st of April. So with that in mind, the changes that we're going to be seeing, that anybody over 23 and over will have their minimum wage increase to £9.50 an hour. And this is right across the board up to the apprentice rate of £4.81. Going on to the next slide, please, Jo. National insurance contributions. As you're aware, from the 6th of April, there's going to be changes in the national insurance contributions. So employers and employees will see their national insurance increase by 1.25%. So as an example, someone earning over £31,000 will probably see £252 extra national insurance contributions, and this will obviously affect their take-home pay. This is all part of the government's funding to help the national health with the social levy that they've introduced. One thing to bear in mind, of course, is that the national insurance contributions going up from the 6th of April will obviously have an effect on employers in terms of the wage cost that they will have to build into their forecasts when looking forward. Going on to the next slide, please, Jo. We've also got increases in other payroll rates. So from the 6th of April, we've got changes in the statutory sick pay, known as SSP, which will increase by £3 a week to £99.35. The statutory maternity pay and statutory adoption pay remains the same, although again, you've got to account for the fact that in the first 6 weeks, it's 90% of the employee's average weekly earnings. This then afterwards will be the lower of the 90% of the average weekly earnings, or £156.66. Similarly, with other rates for statutory paternity pay, statutory shared parental pay, and statutory parental bereavement, you will also see that this will also increase to £156.66, or using the same formula, 90% of the average weekly earnings. The minimum average weekly earnings where you do qualify for SSP also increases by £3 a week to £123. If I could have the next slide, please, Jo. So just as a quick reminder, as we've returned back from COVID, that the normal statutory SSP rules are now in place. The government's temporary concession to claim back SSP under their rebate scheme is now closed. So please bear in mind that you can no longer claim back SSP for employees who are off sick for absence with COVID or self-isolations. And again, you should speak to your HR or payroll to see how that affects the pay. As we come to the end of my presentation, just a quick reminder that if you need assistance with managing your payroll processes, please either speak to myself or our payroll team here at Davis Grant, and we'll be happy to assist you. I'm now going to hand across over to Alan and Katie. Thank you.
Thank you, Joe. Please can I have the next slide, please. Okay, unfortunately, there hasn't been a lot of changes to employment law over the last 2 years due to the pandemic. The government were, after Brexit, looking at the working time regulations, which are governed by the European Union, and also current employment law. Obviously, with the pandemic, that's not happened. So what I'd like to do is take the opportunity to discuss these topics that were on the agenda. So I will be giving you an introduction to Supportis, talking about disciplinaries, managing poor performance, grievances, and discrimination in the workplace. And as Joe said at the end, we will give you the opportunity to ask any questions that you have on those topics. Next slide, please, Joe. Okay, so HR. So basically, we provide our clients with day-to-day advice on HR. We provide bespoke documentation. We represent clients in tribunals, advise through major strategic and structural business changes. We have a dedicated advisor who knows you and your business, which we feel is quite important for them to get to know you and you get to know them, and then you can discuss any issues that you have. We have frequent contact from your dedicated client relationship managers. We also have a client portal, meaning quick access to all previous advice and a full suite of resources available to you. We provide legal expenses cover and support at every stage leading up to any potential tribunals, including representation and any award settlement. We know it can be a distressing and emotive experience defending an employment tribunal claim, and we have a dedicated team that will take you through that process. Our legal experts are in your corner from start to finish of that process. We also liaise with ACAS and the opposing party to swiftly resolve any disputes in an amicable and professional manner, which obviously then protects your business. Next slide, please, John. Okay, so those are basically a list of the specialities that we would discuss with clients. So as you can see, we can provide advice and documentation on appraisals. We provide bespoke policies for your business, contracts for employment, advice on absenteeism, disciplinary procedures, which we'll be discussing, flexible working, casual workers, grievance procedures, maternity and leave pay, and redundancies. Next slide, please, Joe. Okay, so this slides will be discussing disciplinaries. Next slide, please, Joe. Okay, so definition of misconduct then. There is no legal definition of misconduct, but basically what we have is policies to define what type of conduct that your business regards as misconduct and gross misconduct. These definitions to all employees when they start work and throughout their employment are provided in their contract of employment and their staff handbook, which we would then provide to you bespokely, which would obviously then reflect what your business needs. So poor performance via misconduct. Key questions are the employee's actions. Are they deliberate? And if it's deliberate, then that will be misconduct. Next slide, please, Jim. Gross misconduct then. Gross misconduct is misconduct of such a serious nature that it fundamentally breaches the employer and employee contractual relationship, entitles the employer to dismiss the employee summarily. And the maximum award last year for unfair dismissal in employment tribunals was £118,842. So as you can imagine, that will be quite a hit to your business if you lost at a tribunal for a case of gross misconduct. Summary dismissal is dismissal without notice or pay in lieu of notice. Takes effect immediately. The employee's contractual rights and benefits cease. Irrespective of severity of the employee's misconduct, dismissal is never automatically fair. On-the-spot dismissal is always unfair. You have to follow the process, which will be discussed in a minute. Always follow the required procedures and take our advice before taking a decision to dismiss. Next slide, please, Joe. Okay, we'll talk about disciplinary rules and procedures. Employers must provide employees with a written statement of terms and conditions of employment on or before the first day of work. It used to be 12 weeks, and new legislation came in place that you have to issue it on the first day of work. What we normally advise clients is that they can send that prior to the employment start date with an offer letter. So you issue the offer letter and the contract of employment So on the day that the person joins, you can go through that with them, and if you've got any questions or queries regarding their contract of employment, you can discuss it there and then. The statement must include a note specifying disciplinary rules, procedures and appeal process, or direct employee to where they can be found, and that would normally be in the staff handbook. Disciplinary rules make it clear what conduct is not acceptable. So we then go on to formal procedures. The first step with any disciplinary is to arrange an investigation. So think, do you need to interview any witnesses? So prior to the investigation, once you've been informed that there's misconduct has happened, find out what, if anyone has witnessed that misconduct, and then you can take witness statements, which would then provide the evidence that you're going to use going forward. Investigation and any subsequent disciplinary hearing should be carried out by different people if possible. But obviously, if you're a one-man band, then that's not appropriate, and you wouldn't have the people to do that. Under ACAS rules, they would allow for that procedure to be carried out by one person. You can suspend the employer with pay if appropriate and explain this isn't a disciplinary sanction or a prejudgment, and we would issue the letters that the client would then issue to the employee. If there is a case to answer, you write to the employee to set up a disciplinary hearing, giving them reasonable notice. Reasonable notice is normally the minimum of 48 hours. In notification, inform the employee of the right to be accompanied, give details of the alleged misconduct and its possible consequences, and provide copies of the written evidence. As we said earlier, that those would be witness statements or any documentary evidence that you're going to provide at that disciplinary hearing. Hold a full, fair and private hearing. Next slide, please, John. Okay, everyone has the right to be accompanied. Workers are entitled to be accompanied at formal disciplinary hearing by a fellow worker or a trade union official of their choice. If a chosen companion is unavailable, allow one postponement. Alternative time must fall within 5 working days. So if that was the case and the employee informed you that that was what they wanted, you would then issue them what we call a reschedule letter, which would give them those 5 working days. The worker has the right to determine within limits the companion's role. The companion may address the hearing on behalf of the worker, i.e. put their case, confirm the worker during the hearing, sum up the worker's case, respond on the worker's behalf to any expressed view. The companion may not respond to questions directly put to the employee. An employee may wish to bring companion for moral support only. Next slide, please, Jim. Record keeping. Keep records of all formal and informal disciplinary hearings and meeting outcomes, e.g. warnings. Records should be held confidentiality. Records allow follow through to further stages of disciplinary procedure if necessary, and be aware of duties under GDPR. So basically, what we always look at the worst case scenario. The worst case scenario would be that ends up at a tribunal. And the tribunal would always expect all those records, the evidence, the letters, and anything used up to the tribunal for the tribunal bundle. So we always advise that everything is kept that you're using. Next slide, please, John. Right, the disciplinary hearing checklist. Does the employee know why they are at the disciplinary meeting and the possible consequences? And that would be in the disciplinary invite letter. Has the employee received details in writing of the accusation made against them? Same again, that would be in the letter inviting to the disciplinary. Has it been made clear to the employee of the possible disciplinary consequences, e.g. whether the accusation could lead to a warning, demotion or dismissal? That is quite important and needs to go into the invite letter. So that, as I say, they know exactly what might happen at the end of that disciplinary. Do they understand the accusation being made against them? Has the employee been given access to the disciplinary procedures? That would be in the handbook, and that would normally be sent to them in conjunction with the evidence and the disciplinary invite letter. Are they aware that the behaviour connected with the disciplinary investigation is unacceptable? Are they aware of their rights and the employee, for instance, to be accompanied to the disciplinary meeting and also appeal that decision? every employee has the right to appeal the decision. Do they feel that they have been given sufficient time to prepare for the disciplinary meeting? Next slide, please, Joe. Okay, warnings that can be given then. A formal warning should explain the nature of the employee's misconduct. It takes into account any explanations or mitigating factors put forward by the employee. It states the improvement required and state what will happen if the misconduct is repeated. Specify how long the warning will remain live on the record. Give the right to appeal, explaining how and who to appeal, and be recorded. So, as I said earlier, normally the appeal would be carried out by another person, not the person who carried out the investigation or the original disciplinary. Record all warnings, including verbal warnings. Record is essential defending any subsequent unfair dismissal claim, which I mentioned earlier. Warnings should be active for disciplinary purposes for a defined period of time. No time periods for warnings laid down in law. Adhere to the time periods for warnings set out in the disciplinary procedure. If misconduct occurs while warning is still active, move up to the next level of sanction. After a time period expired, warnings should lapse or be reviewed by the manager. Next slide, please, Joe. Right, dismissal for misconduct then. If allowing a series of formal warnings, misconduct continues, dismissal may be appropriate. Dismissal without warnings is unfair unless it's gross misconduct. And obviously dismissal is a last resort. Give the employee the opportunity to appeal the dismissal. Where practicable, appeal hearing should be conducted by a manager not previously involved in the case. As I said earlier, but if it's a one-man band, then obviously that would be appropriate. Misconduct is a potentially fair reason to dismiss. Dismissal is fair only if conduct sufficiently bad and the employer acted reasonably and followed a fair procedure. 2 years service to bring an unfair dismissal complaint required, subject to some exceptions. Guidance in this presentation reflects the ACAS codes of practice on disciplinary and grievance procedures. Unreasonable failure to follow the code may result in adjustment of 25% to compensation. That's why we always advise our clients that they should always contact us if they are going through the disciplinary process, and we can ensure that the disciplinary is being carried out in a fair and reasonable manner, so that if it does end up at tribunal, they're not going to get an uplift from the judge for not following the ACAS code of practice. Next slide, please, Joe. Okay, so the next thing we're going to discuss is grievances. Next slide, please, Joe. Right, grievances defined is guidance in this presentation reflects the ACAS codes of practice on disciplinary grievance procedures. Unreasonable failure to follow the code may result in adjustment of 25% to any compensation awarded. As we said, it's exactly the same as disciplinaries. If the grievance procedure laid out in the staff handbook isn't followed, the judge may award a 25% uplift of any compensation or awards. Grievances are concerns or problems or complaints employees raise with their employer. Grievances can concern matters such as employees' work, pay, or working relationships. Grievance procedures allows employees to raise genuine workplace grievances to be dealt with fairly, objectively, and without fear of recrimination. Next slide, please, Joe. The procedure then, where possible, deal with grievances informally. So the grievance procedure should include the right to raise grievances formally, the requirement to raise grievance with the line manager at first, or alternative person if appropriate, option to appeal the decision, the route to appeal to a more senior manager where possible, timescales for dealing with various stages, the requirement that appeals set out grounds for the appeal, requirement to put outcome of grievance hearing in writing and provide a copy to employee and put a copy on file. So basically what we're saying there is always try and deal with a grievance informally to start off with, but if it's apparent that the employee wants to raise a formal grievance, then you have to have the procedure in place for them to do that, and that would, same again, always be in the staff handbook. Okay, so view raising grievance as an opportunity to resolve a workplace problem. Once the no employer has a grievance, can discuss with the employee, take on board their point of view, and if possible, provide a solution or a point solution. So the whole point of an employee raising a grievance, the first thing you need to ascertain from the employee is what outcome do they want from the grievance. You need to find out from them what exactly they want the solution and the outcome to be. Positive attitude may facilitate satisfactory resolution. Negative attitude likely to alienate the employee and aggravate the situation. Next slide, please, Joe. Right then, so the do's and don'ts of grievances. Make sure that there will be no interruptions. Make sure the effort to put the employee at ease. Allow the employee to explain their complaint. Listen actively to what the employee has to say and take it on board. Distinguish between facts and opinions. Avoid emotional reactions such as anger or impatience. Don't interrupt the employee unless it is necessary to keep the discussion on track. React negatively, for example, by expressing criticism or truthful. Adopt a judgmental attitude. Allow any personal like or dislike of the employee to influence your responses. Forget to summarise towards the end of the hearing in order to check the understanding. And make any decision about what to do about the grievance until all the facts have been aired and, if necessary, investigated or checked. Next slide, please. Same as with the disciplinary formal process, the employee has the right to be accompanied at the formal grievance. If chosen companion unavailable, allow postponement of 5 days. Reasonable alternative time must fall within the 5 working days. Worker has the right to determine in limits the companion's role, as said earlier. The companion may address the hearing on behalf of the worker, confer with the worker during the interview, sum up the worker's case, and respond on worker's behalf to any views expressed at the hearing. The manager is entitled to expect the worker to answer any questions. An employee may wish to bring a companion for moral support. Next slide, please, John. Okay, the investigation. Adjourn the hearing to investigate any allegations raised by the employee. So once you have the meeting, if it's apparent that further investigation needs to be carried out, the meeting will be adjourned. Then you would go away and carry out further investigations, carry out witness statements, get witness statements from witnesses, and then you would obviously go back to the meeting to then go over what you found out during the investigation. It should be impartial and thorough. The manager may need to check the policies and procedures, discuss what the employee has raised with other employees, and check the employee's file. Always remain open-minded. The resolution then, once a grievance investigation, give employee feedback on the outcome. That is normally done in a written outcome of what's been found. Not always possible to resolve a grievance to the employee's satisfaction. The manager should explain what action has been taken or will be taken, or that no action can be taken together, but give reasons for this. Confirm the feedback in writing. Inform the employee of the right of appeal and deal with the appeal impartially. Next slide, please. Okay, where possible, the manager hearing the appeal should be more senior and not previously involved in the case. Communicate to employee the outcome of appeal in writing without unreasonable delay. Once a grievance procedure has been exhausted, inform the employee and explain that there's no further right of appeal. So that will be in the outcome letter. And if the employees want to take it further, that would not be done by the company. They would then need to go to ACAS and look at raising a tribunal claim. The matter's closed whether or not the employee accepts the outcome. So that's as far as the company is concerned. Once the appeal has been held, that's the matter closed as far as the company part in it. Next slide, please, John. Right, we're then going to talk about discrimination. Next slide, please, Joe. Okay, then you're responsible for a wide range of matters, including allocating work, setting goals and targets, conducting appraisals, managing performance, monitoring sickness absence, and dealing with disciplinary and grievance issues. Unfair and possible discriminatory treatment could occur when you are carrying any of these functions. Next slide, please, John. Okay, then, so never assume discrimination will not occur as long as you treat everyone the same. You may have to treat people differently to comply with the law. For example, a disabled employee may require reasonable adjustments to help them carry out their job. Depending on the context, this could involve lowering their production targets or allowing them more time to complete tasks. And apparently neutral actions, such as always holding important staff meetings at 8:30 a.m, might impact adversely on women who are more likely to have primary responsibility for childcare. And awareness of when discrimination can arise will help you to deal with a variety of situations more confidentially. So then, the liability. If an employment tribunal claim is successful, an employee can be held legally liable if the discriminatory conduct in question was carried out by any team member. In some circumstances, individual employees can be held legally liable together with or instead of the employer and can be added to pay compensation. There is no limit on the compensation that a tribunal can award in discrimination cases. And what we tend to find is the no-win, no-fee lawyers around the bazaars, they will always try and look at a discrimination case so that it's unlimited at tribunal. The fact that the business can be held liable for your actions or the actions of those who you manage means that it's part of your role to do all that you can to ensure that discrimination does not occur. Next slide, please. Okay, then lastly, but not leastly, managing poor performance. Okay, then why manage poor performance then? Successful and productive teams, team morale and engagement, recruitment and retention, and achievement of the business aims. So how do we do that then? Appraisals, one-to-ones, meetings, feedback and observations, financial and sales reports, objectives and KPIs. If an employee is pregnant, take advice from Supportis so risk can be mitigated. You should manage performance all the time through regular discussions and feedback, shared understanding of performance requirements, early intervention, and celebrating success. Next slide, please. Okay, the handling complaints. Consequence of not dealing with complaints early is it's harder to resolve fairly. Negative impact on performance of team and organisation. The negative impact on colleagues' motivation. Greater risk of disputes as memories fade, and raises suspicion of ulterior motives. If you do not intervene, the employee may think that there is an issue, but some may not think there's an issue. Okay, so what obstacles then? You open yourself up to criticism as a manager. You want to be friends with your team. It can be time consuming, and you're unsure whether it's part of your role. Slide, please. Okay, so obviously we go down the informal route first. Schedule a private meeting, allowing sufficient time. Review what had been agreed. Give examples of good and poor performance. Set out supervision and support and consider any external factors. Explain improvements required and timescales. Next slide, please. Okay, and always in these situations, take notes, accurately reflect the meeting, set out the agreed action points, type them up quickly, and send action points to the employee. Don't doodle, make personal comments or jokes, and write anything down that would embarrass them. Next slide, please. Okay, so we've gone down the informal process. That hasn't been successful, so we will then look at a formal process. So you implement if informal process does not work. A formal process should not be a surprise. Set measurable objective targets. Don't set the employee up to fail. Hold regular review meetings in addition to ongoing feedback. Consider increased supervision. Set timescales depending on the circumstances. Warnings and dismissal likely if performance does not improve. Redeployment may be a possibility, but don't promise a role. Work with us obviously when required. An important legal process to follow. Next slide, please, John. Okay, then it's now your responsibility to apologise, be honest and open, explain the problem, explore a solution, agree a way forward, and take action, informal or formal. Next slide, please. Okay, managing performance. And so the key points here are that performance management is equals 24/7. Act promptly and take responsibility. Be consistent and fair. Give objective and structured feedback. Be discreet and sensitive and always show empathy. Keep notes of any meetings or one-to-ones or appraisals that you've had with the employee. Set clear performance expectations. Try to resolve the issues informally. Speak to us, obviously, if you're in doubt. Set clear, agreed, and realistic targets. Adopt a problem-solving approach. Aim is to improve performance, not to set the employee up to fail. Next slide, please. Okay, these are just some of the comments that we've had from clients that we represent. And basically, from all what we've discussed in this presentation, those are all the sorts of things that we can help our clients with and make sure that they don't end up in a tribunal, end up successfully dealing with disciplinaries or grievances. They don't set up themselves for discrimination. And if there is poor performance, then that's the way that we would deal with it. Are there any questions? Okay, those are just basically the different ways that we connect with our clients. Next slide, please, Jim. Okay. Any questions from the floor?
Alan, doesn't look like we've got any questions at the moment. They've been listed on there, but if there are any questions, please do forward them on to ourselves, Alan and Katie, and we'll be very happy to assist you. Joe, do you want to put the contact details up, please? So as you can see, here are the contact details for all three of us here, and we'll be happy to assist with any questions if you think of any questions after the presentation. Thank you.